Hello, everyone. This is Banu Güven. Welcome to the report launch of the PEN Norway Turkey Indictment Project 2020. The state of the rule of law in Turkey and the arbitrary trials, pre-trial detentions. These are issues we address a lot. It's been years. However, to see the similarities, the problems in various indictments when they come together, to see them in a report, tell us much more about the gravity of the situation. So PEN Norway, in this regard, has made a great contribution to this discussions, to the discussions on the rule of law or on the lack of rule of law in Turkey. And today we are going to, of course, listen to those who contributed to this report. And also we have some distinguished guests who are also going to make some remarks about the situation in Turkey, and they are no strangers to Turkey. Turkey is not strange. Turkey isn't. I mean, they are familiar with Turkey. So let me introduce you first of all our participants in today's program. PEN Norway President Kjersti Løken Stavrum is with us. And then we have the Turkey Rapporteur of the European Parliament, Mr. Nacho Sanchez Amor. And then we have EU-Turkey Joint Parliamentary Committee Chair, Sergei Lagodinsky. Caroline Stockford, PEN Norway Turkey Advisor, and also Ceren Uysal, who contributed to this report as a supervisor lawyer. Will be with us. Human rights lawyer Ayşe Bingöl Demir is with us as well. And then at the end of the whole panel, I would say webinar, we are going to have some questions, a Q&A session. I think we have enough time for that. So at the very beginning, actually, I started without mentioning the interpretation option. There you see an interpretation button at the right side of the bar. Please, now I'm switching to Turkish. Çeviri için en altta bir interpretation düğmesi görüyorsunuz. Orada lütfen Korece'yi seçin, oradan Türkçe çıkacak. So, en altta, sağ tarafta. I think everyone can hear the translation. I mean, now, I hope so. If anything, please let us know in the Q&A section. You can also write if you have problems or in the chat section. I think we can start. I don't see any complaints regarding the translation, interpretation. So I would like to, and we have Heidi Hegdal. I'm sorry, I forgot to present you as well. So I think we should start with Kjersti Løken Stavrum, the PEN Norway president, with an opening remark. So I give the floor to Ms. Stavrum.
Thank you, and greetings to all of you, and welcome to this launch of the final PEN Norway Turkey Indictment Project report. PEN Norway has been monitoring trials in Turkey for many years. In one case I attended myself, the indictment was a copy-paste from a previous case, including the name of the previous prosecuted person. This report has brought our monitoring achievement to a new and much higher level. 12 indictments in cases involving freedom of expression, the media, and civil society have been studied by an impressive team of legal experts from Norway, Austria, Turkey, and the United Kingdom. And the team, you decided yourself the methodology of determining whether the indictments met with the Turkish standards of the Turkish Procedural Code and the European Convention on Human Rights. In addition to the 12 indictments report, the project also includes 3 academic legal articles and 1 opinion piece. It's very impressive, I think. The aim of our project has been to study any potential shortcomings in indictments in cases involving freedom of expressions in Turkey, and to make recommendations for the improvement of standards in their writing. Our report, I think, carries serious messages to the international society, to all who cares about the well-being of Turkey and the Turkish society. I would like to highlight some of the conclusions based on the study of the Kavala Gezi Park's indictment, maybe because I've attended one of the cases or one of the trials myself. And the report writes, there is a profound lack of balance that runs through the indictment, such that the indictment as a whole can only be said to constitute a profound breach of international prosecutorial standards. The Gezi Park the Gezi Park indictment is regrettably a textbook example as to how not to draft indictments in complex cases. The Gezi Park indictment marks a low watershed in the drafting of indictments in complex and sensitive cases. Not only do badly constructed and unbalanced indictments bring about legally poor and unsustainable conclusions, they can also do immense damage to the public prosecutor's office of the country which draft them. I think this sums up the purpose of the work and carries the message in a very clear voice. We in Norwegian PEN will, of course, continue monitoring the Kavala and Gezi trial and other cases involving freedom of expression, and we will still hope for fairness, improvement, and justice. So, to all of you, a warm thank to all our supporters and all you contributors of this important work. We in Norwegian PEN hope you find the report interesting, relevant, and legitimate. And let's all hope it will make the impressions we hope for and make impact. Thank you very much, and let's continue the important work in any ways. Please.
Thank you. Thank you very much, Kjersti. So I would like to continue with Nacho Sanchez Amor. So you're currently the rapporteur for Turkey for the European Union as a member of the European Parliament. I'm wondering about your impressions about the idea you got from your talks with the Turkish with your Turkish counterparts, you know, because there's been talk of some judicial reforms, and well, when it comes to the bilateral relations with the European Union, there's always talk of some judicial reforms in Turkey, but what are the outcomes? What have we seen? What are we going to see? And how serious is Turkey or this government in improving things regarding rule of law in Turkey?
Thank you, Banu. Thank you, Kjersti, for the invitation. It's a very timely report because sometimes we feel when I have to address a case in Turkey, sometimes we miss the root of the case. For example, I received a message, a student has been accused for using Twitter, but I never had the tweet, you know, probably because the text that created the problem is not to be repeated to other media, but for that kind of things, to have this report with the intricacies of every case is completely useful. And for that reason, I encourage you to continue acting in this way. Well, the relation with Turkey is a very multifaceted, complex issue. You could jump from the first, for me at least, human rights and rule of law issues, from the foreign policy, that means Syria, Libya, the drillings, the relation with Cyprus, Nagorno-Karabakh, and now Iraq. You could talk about visa liberalization. You could talk about migration deal. You can talk about custom union. Is impossible to address every issue when I have to talk in a general aspect of the relation. But at the current moment, what is the current situation? Because you more or less are familiar about what is happening in Turkey. Now we have probably the worst period in our relation. I'm a little bit upset of always repeating the same for starting my words in that kind of meetings, because the Parliament report had to depict what happened in the last couple of years, because it's covering 19 and 20. And this has been horrible in every aspect of the relation. Of course, in the domestic point of view, human rights and rule of law, any kind of real improvement. As you said, we received some minor signals of launched reform, but I want to be very clear, as I have been in the Parliament. We don't want more love letters. We don't want programs. We don't want action plans. We want facts. Simply facts, political facts, decisions. For example, to release the people who have their cases reviewed by the Human Rights Court of Strasbourg. It's as simple as that. We don't want more promises, more statements, more overnight change of rhetoric, from an anti-EU rhetoric to a new pro-EU rhetoric. I could understand that the public opinion in Turkey has to be completely confused of this change of rhetoric overnight. And for that reason, listen, okay, we appreciate a lot the launching of the reform, but we are very tired of that. We don't want to pursue this mouse and cat game. We want facts. We want decisions. We want simply facts and not just programs or action plans or draft reforms.
May I ask you?
Yeah, please.
Something. Well, Turkey has some expectations from the European Union, right? I mean, Turkey claims that it has an independent judiciary, which isn't the fact. We know that. And it has some expectations, like an update on the customs union or free movement of people as well, like things like that. So how serious is the Turkish government really in expecting that these requests can be fulfilled by the European Union? Or how is the European Union, or should the European Union somehow see these things as, or could use these things, these issues as a leverage for a good end?
Yeah, but we have an expectation. Also, we have expectations. We expect a change in the anti-terror law. We expect change in the data protection law. We expect a change in the way to address the core rulings of the European Court of Human Rights. We also have our expectation, and Turkey simply doesn't meet this expectation. But you are right, there is a lot of things that Turkey wants from the European Union, and there are a few things that we want from Turkey. Is you have to be coherent with your position as a candidate country, because sometimes we forget Turkey is a candidate country, and to be a candidate country means you have to approach our values, our standards, our policies, our legislation in a way that could be more speed or more slow, but you have to approach. But what we have seen is a complete divergence. Turkey has been diverging from the European Union in every aspect of the relation. Despite that, Turkey had, in the last month of the last year, an offer of a positive agenda. First, this is an offer coming from the Council, not from the Parliament. This positive agenda has been for several months not linked expressly to the human rights and rule of law issues, coming from the Council, not from the parliament, because the parliament never surrendered our approach to our relation with Turkey. In any folder, in any issue, in any part of our relation, we are demanding changes in the democracy, in the rule of law, in the human rights, in every aspect, because the accession process is not functional for that. If the accession process were a functional process, we could address the customs union or the visa liberalization in a different way. But because the accession process is not functional to drive to reforms, we have to use any other table, any other negotiation to insist in a way. And this is our difference with the Council. We have been very upset in the Parliament because this positive agenda offered from the Council without mentioning human rights and rule of law. And for that reason, we have been warning the Council. If you are coming back to the Parliament to have a green light to the customs union, you have to be aware, if there is no real progress linked to the customs union negotiation, when I say progress in human rights and rule of law, don't expect in any way the endorsement of the Parliament. Or you use the customs union or any other leverage we have to push for the democratic reform, don't count on the Parliament. We have been very clear on that, and you have to be aware, especially our European colleagues linked to the webinar, there are real and deep differences among the European institutions concerning Turkey. But the Parliament is always addressing human rights and rule of law as the core issue of the relation.
As of 1st of July, I believe, right? The beginning of July, Turkey won't be a party to the Istanbul Convention. So it's so sad to call this convention, I mean, Istanbul Convention, and you're not a part of it anymore. So in that sense, we've also seen, I mean, how the police treated the LGBT community during demonstrations and so on. This divergence of Turkey you were mentioning earlier is also encouraging some EU members, maybe in the like Poland, I would say, who also, I mean, where the governments also try really hard to drift away from the European values. So, I mean, I don't know what would, if you would like to say something on that, comment on that, and if you could have any kind of dialogue with your Turkish counterparts on these issues.
Yeah, I myself and Sergei and the rest of the colleagues dealing with Turkey, we have a complete, open and frank and very useful dialogue with the Turkish authorities. We never cut in any way our bridges. I always have, as Sergei has, an open invitation to go to Turkey and to have the agenda I want to have, and no problem on that side. The channels are completely open from the Parliament, from the Commission, and from the Council. This is clear, and I have to say that the Turkish authorities always have been very open and very fair and very receiving that enormous amount of criticism. Concerning the drifting of some governments in the European Union from the core values of the European Union, because these governments, I don't want to say countries, I try to differentiate the government of Turkey as a society is the same for Poland or for Hungary. We have a quarrel with this government because they are drifting from our core values, but we have mechanisms, because they are members, we have our mechanisms, internal mechanisms to address the issue. But when you have to deal with the candidate, this is about the political will. You know, sometimes I receive the message, Turkey don't have incentives enough. Sorry, incentives to become a mature democracy? Do you really need external incentives to want to be a mature democracy, a more free, more open society? This is about the political will of the Turkish society and the Turkish authorities. We can export democracy if you don't want to receive that message or that gift. This is on you. When I say you, I say Turkish society, Turkish authorities. And for that reason, one of the key issues in our relation with Turkey is the sincerity of the offer. the sincerity of the offer from both sides. I have to address also the sincerity of the offer of Europe. If Turkey finally change and start to reform, is it going to appear a kind of religious veto? Because Turkey is a majoritarian Muslim country. And when I ask for sincerity, I'm asking for the sincerity for both sides. But Turkey has to examine if the real political will of Turkey in that moment of its history is to become a mature democracy and eventually to become member of the European Union. But we don't have the moral obligation to drag Turkey, to take Turkey by the lips and drag Turkey to be a democracy. This is all this Turkish society. And for that reason, sometimes this idea of the incentives is completely out of the scope. Mm-hmm. This is not about the incentives. We use incentives with third countries, but you are a candidate country. You have to be clear on that, to have a generational agreement. If this is your goal, let's go. We are going to help Turkey to become a mature democracy and to become a member. But we do really need this sincerity and the political will to walk that path.
Thank you very much, Nacho Sanchez Amor. I would like to continue with Sergei Lagodinsky. He is the chair of the joint committee between the European Union and the Turkish Parliament. Hi, Sergei. Oops.
Hello.
Now I cannot see you, but can you see Sergei?
I have no. Yeah, now you can see me. I hope you can hear me.
Yes, we hear you and we see you, Sergei Lagodinsky. You were in Turkey just a few days ago, I saw. You were one of the participants of this Antalya Diplomacy Forum, of the Diplomacy Forum in Antalya, where the strategic importance of Turkey was stressed, and the power, I would say, the hard power, the military abilities, in a way celebrated in some talks I've seen. So, and also I heard that everyone, including the the former Minister of Foreign Affairs of Germany, was talking about Turkey's possible role in other parts of the world, like Afghanistan especially, and so on. Okay, there is something going on again between NATO, Turkey, and so on. But it was a diplomatic forum. So I'm wondering how much of an issue were these arbitrary trials, this lack of rule of law, or these problems in this forum? Were you able to address these issues, for example?
Yes, first of all, thank you, and thanks for this report, Caroline and colleagues. This is an important point, and I was indeed participant of the forum. The panels that I attended, it was the panel on the role of parliamentary diplomacy, and also a panel with candidate countries, especially from the Balkans. Of course, the issue of not abiding by expectations, mutual expectations, common expectations on democracy and rule of law were mentioned. I hope you can hear me, because you look a little bit, yeah. I'm not sure whether the quality is okay. I also
I can hear you, sorry.
In the parliamentary round, I mentioned also the plurality and political pluralism of Turkey and of Turkish parliament. When we sit down together, it is important for me and for us to hear the voices of opposition parties, including the voices of HDP. And this is something that was important for me also to stress, and I think it came across and was received by the hosts. The picture that I saw was mixed. It was an interesting combination of countries, but mostly of regional countries. And just to make it clear and to avoid confusion, the foreign minister of Germany was not at this forum. And in fact, there was hardly any politician of caliber from Germany or from the United States present at the forum. And this was for me a very interesting mixture of high-ranking diplomats, but mostly from some Arab states, from Afghanistan, from Azerbaijan, from the Balkan states. So it kind of showed to me the relevance of foreign policy relevance of Turkey, but not the foreign policy relevance that probably Turkey would like to have, and probably not what I would like Turkey to have as well, which goes beyond the countries and the regions that I mentioned. And I think it has something to do also with the situation within the country. I mean, I gladly received and responded to the invitation, because I think the discussion and the dialogue has to continue. And I was happy to use this opportunity to talk to the representatives of the foreign ministry, to my counterparts in the parliament, and also to address the issues that we always address. I have a feeling that now we had already the phase where civil rights and media were under pressure, social media are under pressure, and now unfortunately the next stage is the political plurality and pluralism that is now being attacked with the procedure against CHP, against HDP, which we're seeing, something that I warned my counterparts against, because it is very clear that especially the European Parliament will not accept this, and we will be having a lot of issues, even more issues to discuss. Basically, the message that I have given to Ms. von der Leyen and Michel following the infamous Sofagate, which is being misinterpreted by so many as a Turkish mistake. In fact, it was not a Turkish mistake, it was a European mess between European institutions. And yet, there was still a discussion of what happened during that visit, and what Nacho and myself have always reiterated, and something that I reiterated again. I think there is a misunderstanding of what European Union has become, and what European Union is becoming also in the course of our own internal struggling. Of our own, kind of combating our own inner demons of authoritarianism, the European Union, in its self-understanding, increasingly becomes a union of democracies, and not just a market, and not just a union that wants to do, to have a European army at some point. And this is the understanding that I think in the panel where I was, I think became clear. We had, on the one hand, countries who aspired to be members, like Albania, with a great, wonderful woman, foreign minister, a new one, and also the foreign minister of Montenegro sitting on the panel. But at the same time, there was the former prime minister of Romania, a country which is full of corruption, and the prime minister, who was also accused of corruption, who was saying, it's a scandal that European Union is not just letting and inviting all of those countries into the and giving them membership. And I had to explain to him, and I think the people, the foreign ministers, supported me, that we cannot just take everyone in, considering what we have experienced with many members. We need to watch very closely what the democratic standards, the fundamental rights standards are. And this is where we are with Turkey. And our Turkish counterparts have to understand that withdrawing vessels from Eastern Mediterranean is not going to solve the problem. The problems are elsewhere. They're inside Turkey.
Mm-hmm. I'd like to ask you, because you had the chance to meet some of your counterparts just recently, I'm wondering if you were able to talk with them about what they think on the statements on the videos by Sedat Peker. Sedat Peker, for those who don't know him, is well known for his criminal activities. He's a leader of a criminal organization. He's been also called a mafia leader. He's against it, but so he's been in jail for that. Well, he is accusing some ministers or some groups of influencing the police, judiciary, and so on and so forth. So in Turkey, even in the government, there is this knowledge and also somehow disturbance, because it's a known fact now that there are cliques in the government itself, and they're trying to affect the judiciary and so on. And all of this situation, I mean, this situation, I'm wondering if you heard any criticism on that, self-criticism maybe, or yeah, were you able to talk about this aspect as well?
Look, I don't I don't usually talk to my counterparts about videos of criminals, and I don't base my political agenda on some accusations of some shady individuals. I understand and I know that this has a huge relevance for domestic discussion in Turkey, and in fact some people whom I met told me, you know, you have to watch those videos, you have to, I mean, so this is of course a topic, but this is not a topic that I would discuss with some representative of the foreign ministry. What I discuss is the situation with counterterrorism legislation. What I discuss is the situation with rule of law and with people who are still in prison. And I met with family members of some who are in prison. I met with opposition. I met with the president of CHP of Istanbul, with Canan Kaftancıoğlu, and looked into her perspectives. I visited HDP chapter in Antalya, also to express my solidarity after the murderous attack in Izmir. This is how I work. I don't work based on YouTube videos. This is not my, this is kind of not the benchmark of my work. I address.
Well, in Turkey, ministers give interviews based on these videos. That's, I mean, not on the claims.
I know, but I'm an outside actor.
Okay.
I mean,
I was just wondering,
in that sense, an outside actor. So we need to address the issues, and by addressing the issue of rule of law and transparency, we of course kind of react to what we hear. But to be honest, I'm not surprised, knowing the corruption and anti-corruption investigations into the surrounding of the highest members of government in Turkey. I'm not surprised that we learn more and more stuff going in that direction. I think what I had a feeling and I had a sense that many are looking increasingly to 2023. Many have hopes regarding some change, even then or after that. And I do hope very much that the process will not be derailed. I think this is the main point and the main guarantee that we could ask and start asking from our Turkish counterparts, that the process of parliamentary transition or parliamentary elections has to be as transparent and as orderly as it always has been. Leave the media aside and leave certain incidents aside in Turkey. And if the majority of the Turkish population wants a change, this change should be provided to them. I think it is important also to make clear, banning parties and prohibiting parties is not the way that Europeans and European Parliament will accept. We have a very clear position on HDP as a parliament. We have voiced this position on multiple occasions regarding the mayors of HDP, regarding the situation of freedom of this party. And if there will be a ban, I know that some colleagues are already working on that. We will be having a resolution and a position of the Parliament that will hopefully also make a clear signal that we do not we do not expect and accept any move like that. I think you're mute.
I was muted, yeah. So you've been witnessing some trials in Turkey. For example, you've been to Gezi trial in 2019.
Kavala, yes.
Kavala trial. And you must have seen or heard more about some other trials, cases. And here we have various indictments, reports on these indictments, like Deniz Yücel, Nedim Türfent, another journalist, the Büyükada trial, where human rights defenders and others who were just giving trainings were indicted. Well, I would like to hear your the impression you got from these trials, indictments, and so on, because it's when you read them, it's probably not so easy to understand what's being told there, right? Or where is the crime? I mean,
well, being a lawyer myself, I of course read with great fascination what I've seen, for example, on Kavala indictment, and also the ruling of the European Court of Human Rights on Kavala, where they actually have kind of taken apart all the so-called accusations that were brought against him. And I think what we are seeing is a clear deficits and deficiency of rule of law, of justice system, and of the judicial culture in a country where the judiciary has been also not only disciplined, but also, let's say, how would you say it, with the deformed in multiple ways. Because I think that the deformation of judiciary started, of course, even during the Gülen times, and then continued ever since. And these multiple waves of kind of deformation of judiciary, of those who actually, of judges and prosecutors, this has this results in a certain combination of lack of professionalism combined with lack of judicial understanding of independence and understanding of what it means to have kind of what it means to have to be a judicial craft, to be part of judiciary, and Turkey is not unique on that. Following the situation in Russia, I see a very good parallels on that. But I think that the difference here is that in Russia we never had judiciary that functioned. In Turkey, I had a feeling that we had a period where there were a little bit more professionalism and independence in judiciary. But this is maybe a very courageous thesis of me. Many people who were victims of the judiciary throughout the decades in Turkey will probably have a different opinion. So what I see in those indictments is this, and this is a huge problem, because we can change the people on top, but if the people in the system do not bring this understanding with them and have been deformed or exchanged, you know, then we're having a huge structural problem. And that is the challenge that we're going to be facing. So I think what we will need to see is how we can you know, see maybe a transformation which is political, but we will need transformation of institutions at some point, and of institutional culture, especially institutions of judiciary in the country.
Thank you very much, Sergei Lagodinsky. After we're going to talk about the report a little bit more in detail. Afterwards, we are going to have another round with questions and answers. and also some maybe last remarks. I believe I cannot see Nacho Sanchez Amor at the moment, but he's with us, I guess. He'll be with us. We'll continue now with Caroline Stackford. And Caroline, I would like to ask you how you came to this big idea of preparing such kind of a report about the indictments, because we've been talking about different indictments, trials all the time. Seeing them all together has another stronger maybe outcome, you told. What exactly was the reason behind this project, and how did you, what kind of an approach did you have?
Thank you, Banu, and thanks to Nacho and Sergey for their interventions as well. It is very it's a very damning report. I think this is a sort of catalogue of all the violations that go on every single day in Turkey, violations to the right to freedom of expression and the right to a fair trial. And it was through trial monitoring, as Kjersti, the president of PEN Norway, said at the beginning. PEN Norway has been monitoring trials in Turkey in person for over 30 years. I myself have monitored trials for 8 years for different organisations, and it's just as in international observers, it's so disheartening to go to, for especially the Kavala and Gezi trial with so many defendants, 16 defendants, that goes on for years and years, and it's becomes so very clear to a non-legal person that this is a show trial, that there is no independence of the judiciary, that we can't find any evidence despite the indictment being 657 pages long. And the longer the process goes on, and the months and months in between hearings where Kavala remains in prison, he's still in prison now, and it becomes, you know, one gets outraged at how this mockery of justice goes on, and it's a mockery of the role of the defense lawyer, because they stand there and they present what is in the constitution, what is in Turkish law, and what is in the European Convention to which Turkey's been signatory since 1953. And whatever they do, however they explain it, those judges will still not make what we would consider to be the right decision, even if there's a European court ruling. So I basically thought that, why do the judges accept these indictments? I mean, surely it's a very basic logic for an outsider to say, why do they not just return them and say, I'm sorry, come back when you have a case against this journalist? And these journalists are our colleagues and friends, and it's really heartbreaking to see them have to try, like you have been a long time, you've been a journalist in Turkey, to see them having to try and do their jobs. For example, Erol Önderoğlu and well, I could name so many journalists. Evrensel is always under attack with judicial harassment. But even in the case of Şebnem Korur Fincancı and Ahmet Nesin and Erol Önderoğlu that we studied last year, their case went on for 3 years. They'd done nothing other than be a solidarity gesture of being the editor of a newspaper for one day. As a solidarity gesture, they didn't control the editorial line. They had a 3-year court case against them, which is always pressing on their life. Then they were acquitted, and then it's been reconstituted. The case is back again now. So there is this constant cycle of judicial harassment, and it's just a tool to oppress the people and to make everybody live in fear. Yeah, and yeah, the report, I mean, we chose those actual indictments because they were colleagues. It's media, we are a freedom of speech organisation, so we chose the big cases that we had actually been to and studied, like Cumhuriyet, like Barzan Güneş. I will show the report in a moment, just the contents page and the infographics, so that people can see which ones we studied. I will say it was a slightly arbitrary choice last year. We based it on the big cases and the ones we'd attended, and so the important thing is we didn't choose indictments which we thought were faulty. And yet our experts found that none of the 12 we studied, and none of the 6 we've done this year, none of them met domestic Turkish procedural standards or international standards. And yet this year, just to say, this year the project continues, and Ceren Uysal, who's supervising the indictment reports this year, has moved on now to choose the laws in question. So we're looking more at the laws now rather than the sort of celebrity journalist cases, as it were.
All right. Okay. So I believe we've come to the findings at that point. And
I'll just like to show the contents page of the report if I can, so that people can
all
just
right.
see who
Yes,
we
please do.
studied last year. So here we are. And yeah, is that good? So I'll just go to the index page here, just so that people can see the makeup of the report. And I do hope it has been anybody. It is on our website, and if anybody would like a copy of the report in Turkish or English, they can email me at caroline@norskpen.no. So there we are. We have a very good introduction by Dr. Sarah Lila Mehta of the Clooney Foundation and Columbia University, who are doing Trial Watch program in Turkey. She places this in the context of the breakdown of the rule of law in Turkey and the importance of freedom of expression. Then we have Barzan Güneş. He's a journalist, a Kurdish journalist in Turkey. Again, it just shows I think some of our experts said in this report, actually, they felt that the evidence had been collected retrospectively. So it's as if he's a Kurdish journalist, they arrest him, then they held him in pre-trial detention. Then they went through his social media feed for the last 6 years. They pulled out a couple of tweets from 6 years ago about Afrin and Sur, and they said, this is terrorist propaganda. Then they searched his father's house. There were thousands of books. They found 5 that they said were banned, and he was in detention. And yet we went there to his case, and this is why solidarity is important, especially provincial trial monitoring. Veysel Ok, the very good human rights lawyer from Istanbul, and Barış Altuntaş and I went to Iğdır, and we stood in that courtroom, and the judge did release him on bail that day because Veysel argued for it, but the case wasn't acquitted. So these cases, as I say, to a non-legal person, they really don't look very strong, and yet the judges keep ruling for continuing detention because they have no other choice. There's an excellent report on Osman Kavala and all the other 15 defendants in the Gezi Park case, written by Kevin Dent, QC of the Bar Human Rights Committee of England and Wales. That's an excellent report on a 657-page indictment. He did an amazing job of actually wading through all of that, those, and actually the telephone tapping and all the transcripts that were in there were later found to have been illegally ordered. So that was one of the reasons for their acquittal. Nedim Turfent is a terrible case. I would urge people to read that one. He was a provincial journalist who wrote one story about the harassment of Kurdish workers, and he has been in prison for 1,500 days on the 15th of June. He's a completely innocent man he's a provincial journalist from Van, I think, and well, he's in prison in Van now. 19 people were tortured in that case because there was no evidence against him. He wrote one newspaper report. He got death threats from the security forces, and then basically they went to 21 defendants. So beg your pardon, 21 witnesses. 19 of them agreed in court they'd been tortured, or threatened with severe torture. And they didn't know Nedim, and they said in court they withdrew their statements. So there is no evidence there. There is no crime. It's freedom of expression, freedom of the press. Then we go on. Pelin Ünker is a journalist. Deniz Yücel, of course, is a very well-known case indeed. That case is still continuing. The MIT news trial Büyükada is the human rights defenders. Cumhuriyet, yes, that was a very famous newspaper trial, as people will remember. Where the whole of the editorial staff really were on trial. I mentioned Şebnem Erol and Ahmet Bey's hearing there. Their trial has been resurrected again. Then we have Osman Kavala and Henry Barkey. That was also studied by Kevin Dent, QC, and that case has been merged with Gezi now. So I won't go into every single detail. The Ahmet Altan, who's just, fortunately after all this time and after a final decision, very long awaited decision from the European Court, Ahmet Altan is free. Ceren Uysal wrote that excellent report on his case. And we have one on Eren Keskin, the human rights lawyer, and her co-defendants. And then very briefly, before we pass on to Jeren, the judicial administration. So we thought as well as an NGO that it's good to understand the history of the Turkish judiciary. You know how complex things are in Turkey. They're even more hard to understand for us when we come to observe. So we've had an article by Dr. Orhan Ertekin, and he's looked at the history of the judicial administration. It's based on the Swiss legal system, but he's given the whole history of how things are. Then an opinion piece by Berna Akkuzal, which is here, Is This Justice in Your World? Then we have Dr. Kasım Akbaş has written Legal Practice and Bar Associations. That's a very important article too, just to say briefly, what happened last year while we were doing the project is that there was a huge change to the system by which Bars Association members are chosen. And it took down the Istanbul Bars quota from 153 to 13 or something. So there was some kind of deliberate assault on the practice of legal defense in trying to minimize the power of 4 of the biggest bars in the country. So I'll just go quickly to page 191, just to show you the infographic, and then I'll have said enough for the beginning. Can't quite see the top of the screen there. Hang on. Just 1 minute. Okay. Well, very quickly, one of the biggest problems, I think, with the independence or lack of independence of the judiciary in Turkey is the way in which members of this Council of Judges and Prosecutors are chosen. So the Council of Judges and Prosecutors, it's their job to choose every judge and prosecutor in Turkey, allot them to the particular cases or courts or cities. So we have an infographic here on how it's set up and how it has evolved over the years. There have been a number of changes. In 2017, the word supreme was dropped and it's now Council of Judges and Prosecutors. And it's quite hard to see here, but there are 13 members of this council and their job is immense. And it's also their job is also standards of prosecutors' materials and whether these judges should accept the cases or not. One of them is chosen by the Minister of Justice himself. One is chosen by the Undersecretary of the Ministry of Justice, 4 by the President, and 7 by the Parliament of Turkey. But when you say Parliament, it means the head of the ruling party. And Erdogan is also the chair of the AKP. So because he has this dual role, he gets to choose 11 members of this highly important council, which should be wholly independent. So what we would really call for when they talk about judicial reform, this is exactly what needs to be reformed. Another constitutional change back so that perhaps the members chosen by the parliament are multi-party choices. Because you cannot speak of any independence in the judiciary if the president and the executive are choosing every member of that council. Very quickly to finish then, before I talk about next year afterwards, the bars associations, we've shown how the bars associations have been decimated. And then we went on to a mapping of the appeals system. So the legal system, how does it, I'll go back, scroll in again, criminal justice system, and the way a case moves through the courts and how it goes in and out, regional appeal court, court of cassation, and eventually constitutional court. And then after all of that domestic remedy, it can finally, if the case is, if the applicant still wishes to make an application, they can apply to the European Court of Human Rights. But that process can take years. And we know, I would just like to say that I think this report proves that there are fundamental there are violations of the European Convention in every single one of these reports. Therefore, can we really say there is domestic remedy in Turkey? I think this report proves there is no fair trial. And therefore, the European Parliament, I beg your pardon, the European Court should start ruling on pilot cases and it should start dealing with this problem. We don't expect them to take on 24,000 cases overnight by saying nobody needs domestic remedy, but something serious has to be done. And I would also say that I'll speak about the advocacy just as when I finish after Jeren, but yeah, it's a very sad catalogue of terrible violations and human cost in the report.
Thank you very much, Carolyn. So the indictments you chose, as journalists, of course, we know about Nedim Türfen's case, Altan's case, and also Mehmet Altan's case, where subliminal messages were, so-called subliminal messages were shown as or claimed as evidence. Really strange things, the Cumhuriyet case, the indictment. And so you just feel helpless sitting in a courtroom just observing a trial which is based on such indictments with no evidence or just made up evidence. It's really I mean, very difficult to tell how helpless one feels himself, herself, themselves. Like also lawyers, because there's only one thing they can use for defending for the defendants. But then if there's no rule of law, what are you going to do with this weapon? So, Ceren, you are the lawyer here, and you had many friends who had to and still have to go through this very difficult experience, I would say, in courtrooms in Turkey. And you had to go through it again, looking at these indictments. So, could you please tell us about the findings of the report?
Thank you, Banu. I think first I will start with what you have already told. Just imagine yourself as a suspect in the courtroom, but also as a lawyer. You feel sometimes desperate, and you feel like that you graduated and you start to practice your profession, but it's not functioning. It's not functioning at all, and somehow, yes, this is quite difficult, and a lot of lawyers in Turkey, they are dealing with this situation daily. Before starting, even though I'm involved in this project, I still feel the urge to thank PEN Norway and Caroline Stockford for initiating such a significant and brilliant project. As a human rights lawyer from Turkey, I think I'm one of the people here who could really feel the importance of such a focus. For years, we have been discussing human rights violations on different platforms, and particularly the practices against the fair trial principles concerning the prosecution process in Turkey. As you know, trial observations that are being organized for years, the observers were there also to observe, to see what's happening inside the courtroom. And of course, we can go on these discussions. We can talk about the case of Demirtaş, Kavala, Nedim Türfen, and other journalists or lawyers such Kozağaçlı or other lawyers who are in prison for hours. But however, I believe that among many other issues, the most important violations mostly start with the investigation phase. And the indictments are an outcome of this phase. So besides being the legal source of the charges brought against a suspect, the indictments also serve as a summary of the investigation phase. And the reader of an indictment, especially lawyers or the other interested parties, we always have the chance to understand the motivation of the writer, or namely the prosecutor of this text. If you read an indictment and notice that the prosecutor ignores all the evidence in favor of the suspect, you can think that this points out a major mistake made by this individual prosecutor. However, if you read 12 different indictments written by 12 different prosecutors, and if you notice that they all ignore the evidence in favor of the suspect, then it means that we are not talking about an individual prosecutor's mistake, but we are talking about a pattern here. And I believe that the final report, 2020, proves this pattern. And unfortunately, if this will go on like this in Turkey, every single person will have the risk to be a suspect of any accusations in one part of their lives. So, PEN Norway Turkey Indictment Project 2020 wanted to ask whether the analyzed indictments meet Turkish and international standards. And again, the first year's report demonstrated that there are plenty of problems in this matter. The project had a clear foresight on this issue before the starting process due to their experiences on Turkey and especially on the trial observation. And this was the reason why the project aimed to focus on the recommendations together with determining the problems. So I hope that you will always find the answer to two questions when you are reading the final report. One is whether these indictments meet the Turkish and international standards, and the second one is what can be done to improve the quality of these legal texts. And one thing that I want to mention here before focusing on the findings, in our indictment reviews, we are always trying to give information about the background of the case in question, because we believe that this gives the reader a chance to observe how an earlier stage violation turns into a systematic violation of a significant number of fair trial principles. But of course, there is another aim here. We aim to give a face to the suspects because they are not only analyzed objects for us. In our case, they are well-known journalists, civic society actors, they are our colleagues, they are our friends, they are people like us who are trying to practice their profession, however, suffering because of ongoing injustice and because of unlawful practices of the judicial actors. Depending on the characteristics of the indictment in question, the reports focus on the evidence, political comments of the prosecutor, the procedural mistakes, the language, the connection of the crime to the act, and so on. And all the indictment reports centered around the requirements of Article 170 of the current Criminal Procedure Code. This article is defining the criteria of indictments in Turkey. We also try to compare the content of indictments to the requirements of the European Convention on Human Rights, of course, and the United Nations guidelines on the role of the prosecutors. And the reports focused on whether these indictments in question were following these binding legal documents, and unfortunately, the answer is simply no. The issues highlighted in the final report do pose some distinctive common characteristics. All the experts have observed that a great deal of progress can be achieved by merely implementing Article 170 of the Criminal Procedure Code, and this is before even considering the pertinent international laws. However, in almost all of the indictments evaluated, there have been recurrent common findings, such as sections of the indictments have been copied and pasted from police inquiry reports, which is very common in Turkey, and the fact that the language is very complicated, the narration of the indictment is also complicated, and it's weak. The indictments are purely weak, and they have no justification, no connection with the evidence and the acts. And we also noticed that one other important issue is the reasonable doubt. The reasonable doubt is not being supported by any forms of evidence that are essential to formulate such an indictment. Our experts also found a lack of a logical association and reasoning between the accusations against the suspect, their actions, and the evidence presented. I think you can find plenty of examples from the reports. Moreover, many indictments disproportionately interfere with freedom of speech and other related rights, and most fail to present any elements in the case that are in favor of the suspects. Some indictments are criticized also as having been written with a political instead of a legal approach in mind. I think Osman Kavala''s case is one of the most important examples. Altogether with the other Gezi defendants, they became the suspects just because of a political approach. The final report proves that a significant number of changes should be considered by the authorities if they have a will to ensure the right to a fair trial, the freedom of speech, the press freedom, the right to defense, and so on. Therefore, I would like to summarize our recommendations very shortly, and probably after the second year, we will be able to have more recommendations, but the first year's outcome led us to formulate a number of concrete suggestions. First of all, again, the language and the narration of the indictments must be simplified, and the indictments must be built upon a standard format. Here, if you have never read an indictment from Turkey, maybe this can sound a bit abstract or arrogant, but this simply means that the prosecutors should avoid making a single sentence flow for 10 to 15 lines. It makes the indictments almost impossible to understand, to be understood. And of course, all evidence, including the evidence in favor of the suspects, must be provided in order within the indictment. The fundamental elements of the criminal procedural code should be applied, and the authorities should see that there is a pattern here too. If the prosecutors are insistently rejecting to follow the necessities of the code, then the authorities should define a template for the indictments. We believe that such a template could be very useful for all parties of a criminal process. And finally, a vocational training of prosecutors is something that the authorities should consider immediately. An area of training crucial to the improvement of the indictments is that of improving evidence-based justification and how evidence can be connected by way of concrete and legally substantial reasoning to the alleged crime. But of course, a training focusing on human rights and the role of prosecutors is very much necessary when it comes to Turkey. Maybe the final and one of the most important recommendation that we can make after the final report is related to the attitudes of the politicians. They should refrain from making statements related to the cases which have been submitted to the prosecution office. It's clear that such practices do not affect the suspect, not only the suspect, but affect the society. And in such an atmosphere, it is almost impossible to talk about the independence of the judiciary. So as you see, they are not very complicated recommendations, and they're not impossible to be applied, but the lack of these merits means the lack of a fair trial. So not doing them is important, and this part is complicated because the quality of an indictment is directly related to the right to defense, and mainly the mentality should change in Turkey. The instrumentalization of law should be stopped. As I told before, otherwise, unfortunately, it's very clear that every single person might find herself as a suspect today or another day in Turkey.
Thank you, Ceren. Now I would like to go to Heidi Hegdal. Heidi, you are a judge at Oslo City Court, and you had the chance to study 2 indictments last year, as far as I'm informed. So, and now we have this report, and you have many more indictments there analyzed. So how do they compare to the previous indictments you studied?
I'm sorry. Okay, first I can ask that question. And first, I must say that I'm very happy to be in this project. When I said yes to this, which I actually was a little hesitant because I thought that maybe this is a little bit out of my league, but then I remember that all development will happen outside your comfort zone. So that's why I really have experienced with these indictments. The Turkish indictments are very different from the Norwegians. The Norwegian indictments are normally very short and actually very to the point. So this was it was a challenge actually to study these indictments. But
may I ask you which ones you studied?
I had the PEN indictment and also the editor-in-chief indictments with the 3 journalists that took 1 day each to the editor-in-chief of the Cumhuriyet newspaper after the editor there was put in prison. And the PEN indictment was she was a journalist, and she wrote about the Panama Papers and the involvement of the previous Turkish president, Binali Yildirim, I think was his name. I have a struggle with the Turkish names, I'm sorry. She was indicted for insulting public officers and also for defamation and damages. And the editor-in-chief campaign journalists, they were indicted for promoting terrorism in their articles about the Kurdish should I say, fights on the eastern part, on the Kurdish part. And when it comes to the first indictment, my indictments, none of them were actually very long, which is quite normal in the Turkish indictments, but they were almost unreadable. Even when translated and made easier for me to read, it was very difficult to grasp what is the crime. I mean, it said it was insulting public officers, but it was merely a reference of what was in the Panama Papers. And as Sharon also told, that there is no attempt even to connect, and it was in both indictments, there is no attempt to connect the evidence that is stated in the indictments to the crime, to the different elements of the crime. So when you read the indictment and the evidence, you see that either there is no crime, or the prosecutor has kind of forgotten that part of the indictment, which is ruled in the Criminal Procedure Code, Article 170. And actually, the editor-in-chief indictment was in the structure quite good, but also there it was impossible to find the crime when you read what was stated from the articles that were written. And there were in the Anchored indictment, her defense was actually referred in the indictment, but it was not discussed. It was not dismissed. It was just neglected. In the editor-in-chief indictment, there was no evidence that could be in the favor of the indicted persons. Also, of course, the presumption of innocence is ignored in both. Freedom of speech was mentioned but not addressed. Freedom of the press, it was just dismissed in the Anker case. And also the other freedom of the other ECHR articles that were applicable were not mentioned. And what can I say about the recommendations? It's the same as Sharon was addressing. It is a simpler and more readable language, but that, I must say, is a problem also in Norway. Even if our indictments are short, the language is very legal and technical, and I would guess that many indicted persons, they don't understand half of it at least. So that could be something we could learn, all of us. Article 170 in the Turkish Criminal Procedure Code is very good. I actually wish we could have an article like that in our own Criminal Procedure Code, because it could be actually used as a checklist. So what I recommended was that article is used as a checklist. is to see if all the formalities are in place, the dates, the date of the crimes, and the evidence are listed with dates of each evidence and how it's connected to the alleged crime. And I think if you follow 170 thoroughly, the indictment would be in line with both human rights, international standards and human rights standards, and also the standards for prosecutors. So I think that is, shall I say, more or less what I can say about the indictment. But of course, it was said, why does the judges accept these indictments? But the PEN indictment, the first time, was not accepted by the judge. And it was sent back to the prosecutor. And then, of course, they find another judge that will accept it. So the core problem is that there is no independence for the prosecutors, even if there is their duty to be independent and fair and impartial. It's not possible for them, many of them, in these high-profile cases, I think, because everything is ruled by the palace. And what can we do with that? I don't really know, but we love Turkey, and we believe that there is many good forces in this country that will work for changes, and we want to participate in that. At least that's what I want to do. Thank you.
Thank you very much, Heidi Hegdal. So I would like to go back to Caroline Stockfort. So what is next in the plan? So, but there are lots of other indictments. You know, I just saw one, Caroline. I won't tell now which one, but a very important one, a political one, and which went to the Constitutional Court, and the Constitutional Court accepted this indictment. Which one? There are some sentences referring to some statements of some politicians, but they are not, I mean, in brackets, you only see like fill in the blanks. They haven't written the statement, which was taken as an evidence put into this indictment. There is even not a quotation from this person, you see? So I am sure that you will have lots of interesting indictments to study.
Yes, as you say, Banu, it's a systemic problem, you know, and there are so many indictments we could study. We mustn't forget as well, there are between unofficial figures, 50 and 70,000 students in prison in Turkey. That's just students who've been swept up under the anti-terror law, potentially. Many of them may be Kurdish. What about their indictments? What about, what we would call for is for the Ministry of Justice to undertake an urgent review and a reform of indictment writing, and there should be retrials in these cases, in many of them. If the indictment is not sufficient, then there is no case. You can't, you know, the prosecutor doesn't really come up with much new evidence during the course of a trial we've seen. So the indictment's the only thing they've got. I should say, first of all, I mean, I will explain very briefly that what we'll be doing this year. We are studying 10 more indictments this year, but I would like to thank, first of all, our experts from last year. I didn't name them one by one, I'd like to. So Judge Heidi Hegdal, who we've heard from, also QC's Kevin Dent and Asghar Fujita from the Bar Human Rights Committee of England and Wales. Two lawyers working together, Hannah Beck and Clarissa Fondi, are working with us again this year. They're from Vienna. And of course, the great Ceren Uysal, who's such a very strong part of the project. So last year there were 12. This year we have concentrated more, after Ceren's advice, on different laws and how. So in taking indictments where we want to look at the law that's involved in that case. So we've already, with a great team, we have a lawyer from Italy, Ezio Menzione. We have a very good lawyer from from Norway, Vidar Strømme, who's a very well-known, extremely good lawyer. He's already studied his case, which was Bülent Şık, Ahmet Şık, the journalist's brother, who reported on unsafe materials cancer-producing materials that were put out by the government, and there was a freedom of, again, it was a clear freedom of expression case without going into too much detail. Hikmet Tunç, Seyhan Avşar, Mavioğlu and Demirel. So we're studying this year as well, we're expanding it not just to journalists, but to filmmakers. So again, it's freedom of expression issue. The film Bakur, which was a film about activities of the PKK brigades in the mountains, and it was a documentary made several years ago when relations were good, and that film was banned, and Mavioğlu and Demirel, the directors and producers of the film, were on trial. So Ezio Menzioni has examined that one. We're also looking at, we're fortunate to have Tony Fisher, who's the former chair of the Law Society in the UK. He's going to study Can Dündar and Erdem Gül's indictment. So yeah, I think we will concentrate on specific laws and 10 indictments this year. We will have, we hope, an exploration into the linguistic rights, because PEN is all about freedom of expression, but also linguistic rights, writers in prison. So we want to look at the linguistic rights of Kurdish defendants in court cases. There is no standard provision for interpreting, which is a very important point. And I'd like to thank our interpreters while I'm at it before we forget. We usually forget to thank them, but thank you very much to both of our interpreters today. But Nedim Turfant, for example, couldn't speak. He's not allowed to speak Kurdish in the court. They write it down as they have begun to speak an unknown language. Then he asks for an interpreter. So they go into the hall and ask for a policeman or a guard or somebody nearby who can speak Kurdish. And this is not good enough. This is, again, a breach of the right to fair trial. They sometimes then will misinterpret, of course, what the defendant is saying. So that's something else we're going to do a survey on, of defendants who have tried to use their native language in court, and we would like to recommend specific qualification would be enough, and a list of interpreters to work from. We're looking at the Jin News, the feminist women's news collective, and how it operates, what it's made up of. So we're studying the role of a woman court reporter. We're looking at the articles will be more generalized and less connected directly to the law. But just to say that the phase after that, of course, is our recommendations, our advocacy with this report. And I think we will, of course, want to have conversation with the Ministry of Justice and with the Justice Academy, because the objective of this report is to stop having 657-page indictments that keep somebody like Osman Kavala in prison for 16, 17 months without knowing with what he's being charged. You know, you have to be brought speedily before a judge, and you have to be able to understand the charges against you. And it's actually a violation of the right to understand the charges if you give somebody 657-page document, which has a lot of irrelevant material in it. So we will be recommending training, a standardization of indictment writing, and a stop of this practice of taking so long to write them. And then we would like to work in cooperation, obviously. We were prepared to work with the Justice Academy to formalize the training and put it in place and offer the training to prosecutors and judges in Turkey. We've been in touch with HELP, Human Rights Education for Legal Practitioners at the Council of Europe, to ask if they will create a program. They've been very cooperative in our communications, but I think it takes a very long time for them to produce their online training courses. But I still think it would be a good idea to have an indictment writing training course online provided by the Council of Europe. And speaking of which, I mean, I think it's very difficult when you work in this job, you know, to know how we can make an impact. We are gathering data, we're reporting, and I think it's beneficial this year that we as a freedom of speech organisation have teamed up with these lawyers, because we have produced something more scientific, more concrete, that will help us all to advocate. But who do we advocate with and to? We know that Sergei Lagodinsky and Nacho Sanchez Amor are doing a strong job of representing democratic values and trying to encourage Turkey. I would say one thing before I conclude, and that is when Nacho Sanchez Amor mentioned earlier, the will of the Turkish people needs to be for democracy. I absolutely think it is. I'm 100% convinced that most people in Turkey would like to have freedom of expression, a functioning justice system, functioning education system, everything to go back to what it should be. And I think that again is and I know he knows this, but the problem there is that they may want that, but how can they get fair, impartial, pluralistic, and critical journalism, objective journalism? They can't when you have 85 newspapers were closed in 2018. People can't get information fairly and objectively. So it all comes down to journalism. All of those issues come back to supporting newspapers like Evrensel, subscribing to them as people who live abroad ourselves, support them, and we have to do our best, because once the people are informed, they can make better decisions, perhaps at the polling booth. But just to finish then, so I think it's actually also, I would like to speak to the Turkey advisor of the Secretary General of the Council of Europe and say, we can prove here that there are systematic, willful violations of Turkey's constitution, of the press law, of the procedural code, and of the European Convention on a daily basis. This is an institutional practice, and therefore Turkey should be chastised over this. And we want really strong measures, because a fair trial is for everybody.
Thank you very much, Caroline. Now, you listed some possible steps which could be taken. These are your recommendations, and certainly the judiciary in Turkey at the moment needs a reform, constructional reform as well. And I don't know what you would like to say on that, Ayşe Bingöl Demir, as a human rights lawyer. Well, you also witnessed, like Caroline Stockford said, these violations of basic rights, rule of law, every single day, multiple times. So what could be done?
Thank you very much. I would also like to start by thanking PEN Norway, Caroline, Jaren, and all the team for this very important and comprehensive work that have a potential to generate an impact that we will be discussing. I am sure that Caroline remembers, I think it was in March 2018, we had a meeting in Berlin with several international organizations, and there we were questioning effectiveness of the European Court of Human Rights in response to the still ongoing human rights law crisis and rule of law crisis that becoming more and more serious, and it was the case at the time. And then one of the suggestions that were made during that discussion was to create evidences, stronger evidences based on facts, examples from the practice, statistics, and other materials to convince the European Court of Human Rights and other international oversight mechanisms that the issues in Turkey are systemic issues. There are patterns going on. There are questions around effectiveness of the domestic remedies in Turkey, which has been relied on by the European Court of Human Rights heavily in many groups of cases. So this work is an important one because, as we have been discussing, has been looking closely into a very important aspect of criminal prosecutions. And I am sure that my colleagues from Turkey would understand that, because indictments do not remain as the charges, documents of charges. In the end of the prosecutions, they turn into the final statement of the prosecutor, and then it turns into the decision of the judgment of the court, and then it turns into the decision of the appeal courts. So that document that has been focused by PEN Norway team doesn't remain in its own legal form. It evolves, it changes, it is being used in all the stages of it. And I think that it's very important because through, as Ceren described, through this report, we can clearly, easily identify some patterns. And those patterns are important, and I am sure that for the future of this work, those patterns, there will be some more additions to the patterns that we have been discussing. For example, I think it's very important to hear from the expert who worked on this report's analysis, having different backgrounds, coming from different jurisdictions, different cultures, different professions like judges, academics, lawyers from different kind of countries, to agree on those patterns. So this is not an argument just made by lawyers in Turkey that might create some views in the outside that, you know, it might not be actually, it might be biased maybe, but this is not the case. This work clearly shows that all these experts agree on certain things. And I think one of the most important part of this, it clearly shows the politicized views of the prosecutors in their indictment making investigation, carrying out procedures. So we don't, it's hard to see those indictments as legal document as agreed by those experts. And there is an ideological bias coming from the prosecutor's side. This is clearly also indicated and could be traced through the report. And we saw that clear practice of criminalization of legal activities of human rights defenders, journalists, and etc. People who are using their freedom of expression, people who are using their freedom of peaceful assembly, freedom of association, being criminalized because of that. And this fundamental lack of evidence that you see in those indictments, you see no sign of evidence, nor you see any link that could be established between the accusations and those lawful exercise of one's rights and freedoms. And what else we see is that the prosecutors in Turkey do not only fail to meet international law standards, they don't follow their own rules and regulations, like the failure of the prosecutors to reflect on Article 170 of the Code of Criminal Procedure, or the constitutional principles around human rights, rule of law principles, and their own ethical conducts, I would say. And this idea of mere act of classifying all the disagreements with the government as a way of supporting terrorism or as a way of denigrating state institutions or so. So if you are critical to the government, the prosecutors in Turkey could clearly indict you for your views and everything. And also this very important fact that there is no evaluation whatsoever in favor of the defendants or the suspects in the cases. Their identities as journalists, as human rights defenders, are not being taken into account at all in those indictment making processes. And also presumption of guilt as opposed to presumption of innocence, coming directly from the prosecutors, like extremely ideological and polarized views. I think, you know, these are just few important things that we could identify while analyzing those indictments that reflect on thousands and thousands and thousands of other indictments, other investigations in Turkey. And so we do have this information. That meeting that we were talking about was 3 years ago. And this human rights crisis and rule of law crisis in Turkey has been ongoing, let's say, since maybe Gezi Park protests, that, you know, there has been some cornerstones in the process. But we have been facing with that difficulty, that challenge from the European Court of Human Rights or other international oversight mechanisms, that we didn't have enough evidence to illustrate the patterns. I think the work that PEN Norway has been carrying out, together with all the works that hard work, the lawyers in Turkey, rights defenders in Turkey, and whoever working on Turkey situation in Turkey together, created a very strong basis. It contributed into that basis that the European Court of Human Rights, for example, in Demirtaş's case or Osman Kavala''s case and many other journalist cases, came to the conclusion that the judicial system in Turkey is not functioning properly. We can see the trace of this in all the judgments of the European Court of Human Rights, especially in Demirtaş and Kavala, where the court openly said that though the criminal investigations against Osman Kavala and Selahattin Demirtaş pursued a political purpose. Those people were investigated, indicted, detained for political purposes. And despite that, right now we have this concrete wall in Turkey that even the judgments from, very clear judgments from the European Court of Human Rights are not being implemented. So I think that first of all, it's good to put the name that the work that has been going on, done by the human rights community in the, or civil society to create that basis has been a very, very comprehensive one. And it has impacted the developments in the area in the way the European Court of Human Rights or other oversight mechanisms have been reacted to Turkey cases, but there is still, of course, ways to continue to work on it to, for example, ensure the right response from Turkey. And in doing so, Mr. Sanchez Amor and Mr. Sergey, they discussed the institutional differences in the views in the EU and other mechanisms. I think these differences should be overcome, and whatever contribution that could be made in that one, that should be made. So the human rights law crisis and rule of law crisis in Turkey should be the core of any relations the European Union and the Council of Europe or the individual countries must have in Turkey or would have in relation to Turkey. So without any improvement, any political view in making the changes in relation to that, those relations should not be optimistic or positive on the tone that, you know, the EU or the Council of Europe don't pay any attention to those cases. So I think through all these discussions we have been making, and the report of PEN Norway being an example of it, we see that the issue is not a technical issue. So issue is a very structural, a very systemic issue, having lots of links with political will, political changes, political party that is governing Turkey. And without that will, of course, that impact that is being aimed at generated will be very hard to do. But of course, the report gives a very clear guidance on what the prosecutorial authorities in Turkey should do in the idea that the independence and impartiality of the judiciary is secured. Otherwise, I think that, of course, you could train the prosecutors, you can give them directions, you can do this and that. But when you have a government that is directly interfering with their work, when they don't indict someone, they are being criticized, they are being removed, they are being disciplined, and they are under the fear of prosecution or identification with terrorist organizations or so, with all the fear that the atmosphere generates, the trainings themselves would not be enough. But it is an important component in the road that the judicial independence and impartiality in Turkey to be secured.
Thank you very much, Ayşe. I have to tell you at that point, where you left, that I personally, as a journalist, heard some years ago from not one, two prosecutors that they couldn't bear to let journalists go so easily because they feel themselves threatened. If they should be acquitted, then it should be the court's duty to do it. We as prosecutors, they said, we are supposed to send them to the court. Otherwise, we may be expelled as well. So, and one of them, I guess, who isn't at the same place where he used to work before. So it's a very important point, I believe, you made. So, but I think that this report is going to have another kind of impact when you go, and if you will have the opportunity, Caroline, if you would go and talk to the Ministry of Justice, for example, because it's not only about, I mean, these are not only statements, I mean, which are taken or seen as political statements by some non-governmental organizations. These are very concrete findings. So it will be, I believe, also of some help for you, for example, Nacho, Sanchez, Amor, maybe having all these indictments, some of them like 650 pages, some of them some other hundreds of pages, you know, long, and impossible, almost impossible to get translated into English or another language because of the difficulties Caroline and Jeren also have mentioned. So do you believe that this report could also help you to, when you talk, when you meet your Turkish counterparts, or when you write another report now, to your findings?
Yes, yes, it's very useful because of the reason I evoked in the beginning. Sometimes we receive a lot of information, but not having the real background of the case. Indictment of the political approach, of the examination of the indictment, for us it could be very, very, very useful. But sometimes I notice from our European colleagues, you are assessing the situation of the judiciary in Turkey with European standards, and you have to forget completely the European standards. I know, you know, as I know, some judges that are very professional, some prosecutors that are very professional, but they are in a complete poisoned system. And when you say, no, we have to ask the politician to refrain to talk about living cases. But this is part of the mechanism, because this is a warning to the judge and the prosecutor to say, be aware, you'd better behave, because this is a political case. You don't need to call by phone to the judge or the prosecutor. You simply, as a ruling elite individual or member of the AKP, or member of the pro-government newspaper, you warn the judge and the prosecutors and even the lawyer, be aware that this is a political case. We are following the case very closely, and if you don't behave as we expect, you are having consequences. This is part of the mechanism. For that reason, you have to change our mindset when we refer to the judiciary system in Turkey, because this is not about having a good quality, technical quality legislation. This is about the mechanism of the ruling elite case in which they consider political gain, or there is a political to crush any kind of professions like doctors or lawyers. This is about that. To ask, let's talk to the Council of Europe if they could prepare a kind of course to address the prosecutors to do a better understandable writings. This is not about that. This is not about the technical capacities or skill of the prosecutors that I'm sure are more or less the same than any other developed country. This is about the political system taking hostage the judiciary to advance in its political agenda, is to maintain the power at all cost. And this is the issue. And we can address the situation in Turkey as if was a country developing a more mature democracy, because this is not the case. This is a case that downgrading gravely the democracy. The problem with Turkey is not the level of democracy. The problem with Turkey is this is a country which is going backwards in the democratic standards, and for that reason, I think we have to be aware of the political mechanisms that they declench to put pressure on judges and prosecutors, even if the judges and prosecutors could be good professionals. Why not? It is true that there is a big problem in Turkey, is they remove, I don't know, a third of the judges, an enormous amount of prosecutors, and immediately they replace them with more young people educated in that system of the political influence, educated and trained to follow this system. I'm sure that there could be elder judges, senior judges with the old professional format, but the young one who has been appointed by the government, they have been educated in that system of the political influence as a part of the daily life in a court. And for that reason, we have to I appreciate it, of course, that kind of tools to try to touch the issue from the professional or technical point of view. But the problem is not technical. The problem is not, I'm sure the law faculties in Turkey are excellent and are excellent professors and they are excellent professionals. But the problem is the system, because the system has been shaped in that way, especially after the constitutional reform that have drive to what I call the authoritarian interpretation of the presidential system. The problem is not the presidential system, because they always say, no, presidential as United States, as in France. No, the problem is not. It's your authoritarian interpretation of the presidential system, in which there is no parliament, there is no almost government, is everything around a small entourage of the president barricade in the palace.
So how will the next report going to look like?
Well, it's a good question for me. It's a good question because I know we are in a different step, because there was this offer of a positive agenda from the Council of the European Union, because there is a good tone in the last statements from the Turkish authorities, but what we do expect are facts, are real reforms, and not only plans. And this is going to be the key question in my next report. Is Turkey changing things in the reality, or only planning things for a future, or just to allow to open some political chapters like custom unions? Is that way? What is the level of sincerity of the new rhetoric coming from Turkey? This is the key question I have to deal with in this year, in the current year.
Thank you very much. Well, to our yes.
Could I just come back in on a quick question there?
Sure.
I do agree with Nacho. I mean, we're not that naive. We do know this is a systemic and this is a problem that's coming from the top. We're aware of that, but I don't think we can underestimate the value of training, because there are 4,000 new judges and prosecutors. Many of them have just come straight from law school, straight onto the judicial panel. The 2-year period of internship was scrapped because there was a shortage of judges and prosecutors, I beg your pardon, judges. And when we met with the Constitutional Court 2 years ago on a mission to Turkey, they told us they were considering bringing in the Netherlands system of 4 to 6 years of internship, but that hasn't been realised yet. That would be a good thing, we think. So training is important, and also so is setting a structure and a framework for when there is political will. And that's sometimes the only thing we can think to work towards is, we know that it's not going to change overnight. And we know if there was political will, Turkey could make a quantum leap forward in meeting EU standards or in protecting and enforcing rights and freedoms. But we do believe in setting a framework so that when that political will does come into play, there will be, everybody will have a fair playing field, and there will be correct training and methods to do that. And yes, and just a final point on what Nacho was saying, it is a political problem, but there is a political answer, and that is to change the selection method of these judges and prosecutors council. So that should be a demand of the EU and of other advocates, you know, and those in conversations with the government and with the Ministry of Justice should be saying this HSK makeup must be democratized. It must be changed so that it's taken away from the executive's power and made more transparent, I would say.
May I ask a question to you all? I mean, if the judges who came like through without any internship, as you mentioned, Karen, who are positioned in heavy panel courts at the moment, if they are politically biased, really, and didn't have the training and education they should have, actually, what are the chances to change things? So I don't know, maybe feel free to comment on that, but I'm also interested in Ayşe's opinion on that.
I just going to jump in with Ayşe is the expert, but can I just say, I think I've noticed in Turkey there is an issue where it's not the organ of state that is recognized, but it's the individual. It's all about the individual, the power of the individual, the power of their ego, and therefore the people in certain public positions believe it's up to them, it's their role, and it's actually the role itself that is important. It's the institutional obligations that are important, and it's not about people power. And there should be the training and the emphasis should be on you know, the guidelines to be a good prosecutor, and certainly not on how you feel and a personal interpretation. But Ayşe Hanım obviously knows the best.
And no, I absolutely agree with you, Caroline. And I think that you know, you can read it through the report, and we all agree on the fact that the issues around independence and impartiality of judiciary in Turkey is not new. Of course, we are now dealing with a more serious structural institutional failure, but it was there in the past too. And we, through our practice, all the lawyers in Turkey that are dealing with politically sensitive cases have always seen the bias. How the bias of the judges and prosecutors played a role in the political cases. So it does have at play, but the safeguards that Caroline mentioned and we have been talking limits that role significantly. So when you ensure that the institutional independence of those mechanisms are protected and there is no governmental influence in it, the way that those judges and prosecutors are being selected and appointed and their role are being managed respects the principles of independence and impartiality. I am sure that even though those judges and prosecutors who had that bias, they would not easily kind of rely on that bias in their decision making, in their dealing with the cases. But right now, Banu, what you say is very important. Before I left Turkey, I think it was around 2016, I remember that when I was facing with prosecutors and judges, increasingly, I would see the hatred that those people would have towards the people, the suspects they were hearing, or people they were investigating, or the people us as lawyers who are representing those people. So that bias you would see it clearly from their faces. They the way they approach it, the way that they have those strong feelings against you. And unfortunately, currently, I think we are almost sure that many of the judges and prosecutors who are appointed to deal with those cases are coming from that's political line, that's ideological line, and they are free to apply to their bias in their judicial practice. And I hope that in the future, when all these issues are properly addressed, that political will is there, and we reach that, we will manage to limit that role as much as we can, and hopefully we would not have those politically extremely biased people as prosecutors and judges.
So the efforts regarding the technical side of the whole thing and the political efforts should go hand in hand in that case. So in that respect, this report gives us a great possibility, actually also for us journalists, you know, who are trying to tell the outside world what is going on in the cases, in the trials, you know. We are accused of being terrorists and so on and so forth. It's not easy to tell, really. So it will help. And at the same time, the political efforts, as Nacho, Sanchez, Amor mentioned, if they will go hand in hand, these trainings could also have some positive results, I guess. So we are almost out of time. So another question here from Ola Kvarnström. Thank you for your question, Ola. The other questions were already answered. And this question of yours, the strategy and action plan of a judicial reform in Turkey, we addressed as the first thing in our session, actually. So action is needed was the answer. Thank you very much for your question. In short, I mean, I tried to tell you what we've discussed about this promise of the Turkish government, which never gets fulfilled. I would like to ask you, Heidi and Ceren, if you'd like to have some closing remarks.
Thank you, Banu. I think everybody explained the details of what we are trying to do. I will just make one comment. I believe that every single issues related to technicalities, they are also political. And, you know, having the problems related to technicalities, it is also because of the political will. So I think we are trying to combine all this together, and I hope that you will read the final report, because at least in 4 or 5 reports, you will see that the reports are mentioning that, hey, these comments from the prosecutor, they are political. They are political and they are not legal. So I hope that we will work all together with this report and will have a contribution to the ongoing situation in Turkey.
Yeah, well, what shall I say? I'm not an expert on Turkey, but I have come to really, really love the country. And I see and hear so many, what shall I say, insightful people that actually believe, Turks that believe in changes. And I think that it's good to be prepared when the changes come. And that also there are a part of the judiciary that is not political, that is working. I mean, even in the worst of times, there are, in all countries, there are parts of the judiciary that actually works. I mean, for common criminal cases. And I think that like a shape up on the indictments can have a good impact on that part of the judiciary that is not political. Also in the future, when it comes to judicial changes and political changes in Turkey. And we wouldn't be doing this work if we didn't believe that all together, with all the efforts, not only ours, but all the others that care about Turkey and want to see Turkey come to both to Europe and to a better to a better and more mature democracy, I think that we just have to continue to do as good as we can.
Before closing our webinar, once again, Sanchez, Amor, would you like to add something? And Caroline, maybe we should.
No, thank you. Thank you. Just for the discussion has been very, very exciting discussion, and I'll follow closely your work in the future because it's going to be very useful for my report. Thank you for your work, and thank you, and congratulations for the report on the indictments.
Thank you very much, Nacho. We will continue. You can be reassured that we will. I'd like to thank as well our Turkey coordinator from last year. Put a lot of work into the report, and our Secretary General Hege Nuth deserves a lot of thanks as well for supporting the team. We translated these indictments because we wanted them to go down for posterity, for people everyone to be able to read and see how our colleagues were judicially harassed. And we just want to say that PEN Norway will continue, and we continue to stand in solidarity with all our friends and colleagues in Turkey who want to have a free media and freedom of expression. And we are inspired by their solidarity, but they show us what solidarity is and also what resistance is, and we're very grateful. And yeah, we look forward to continuing this year with our team.
Thank you so much, Caroline, and the whole team for this very, very important contribution to the struggle for the rule of law in Turkey. And we'll hear more from you. Thank you very much.